Did you know that 90 to 95% of all criminal cases result in plea bargaining of some kind? Are you aware that most people charged with a criminal case will at one point or another consider whether or not they should take a plea? In this video today, we're going to discuss some of the factors that go into that decision, and we're going to discuss a topic that's really important to us and one that affects us personally and professionally. And that is the topic of whether or not a person who is innocent of the crime should nonetheless consider taking a plea bargain or even discuss it with their lawyer. Roland, I don't know what your experience is with this, but for as long as I have been a criminal defense attorney, which is now 2 decades, every time I meet a new person and they find out what it is that I do for a living, they always ask me the same question. You know what that question is, right?
Well, the main question that we hear all the time is how can you defend guilty people? And in our system, I think everybody deserves a defense. And one of the things I heard years ago, and this is what I tell everybody that for the system to work, if we're defending even the most despicable criminals and putting up a vigorous defense, that protects the innocent people. Because if we're willing to fight that hard for the guilty people, we should be fighting even harder for the innocent people. And that transitions into the question, what do we do when we have a client that we feel is truly innocent?
It's just very interesting how you explained it, and I think that maybe every lawyer rationalizes it a little bit differently. But for me, I always say that defending a person I know is guilty is actually quite easy for me. It's not easy in the sense that the case is uncomplicated. Quite often these cases are filed after very lengthy investigation. There could be a lot of evidence to review. You need to do a lot of investigation, consult experts, forensic experts, psychologists, whatever the needs of the case are. But for me mentally, for me psychologically, I already have an approach in mind. And when I know that a person is guilty of at least some crime, I know the framework. And that is, I need to take a look and decide what are the circumstances that led to criminal behavior, what can be done to make sure that this criminal behavior does not reoccur. I know how I'm going to present the situation to the judge or the prosecutor after I've done my due diligence and I've investigated the case. But what really keeps me up at night, and I think what keeps you up at night and many of our colleagues, is working with the client when you know in your heart, sometimes I go to the jail and I meet a client for the first time, right? You know what I'm about to say.
Yeah.
You go to the jail, you meet a person for the very first time, and you get that sinking feeling, like in the bottom of your stomach, that you think to yourself, holy shit, I think this person is actually innocent. And I think you and I, after respective visits, have actually texted that to one another when we have done a consultation or visited a person for the first time.
I do feel that way from time to time. I believe that puts extra pressure on us when we're going to trial. However, I think our approach still is that we treat every client the same, whether they're innocent or guilty. We go through all the steps. We investigate the cases fully. You can't short circuit anybody because you think they're guilty. In your approach you were talking about, what's interesting is that's more a holistic approach, and you're looking at, well, let's assume that he's convicted. Let's front load as much of the mitigation as we can. Let's get him treated. Let's get him in a position where he's not coming back, where we don't see that man or woman again. We're treating their mental illness. We're treating their drug addiction. We're looking at
homelessness,
whatever the root causes to get that. And more so you than me is thinking about those issues from the very first time you meet them. And what makes us effective together is sometimes I'm looking for every defense I can find for that person to get them out of trouble. And then the flip side is, even when we get somebody out of trouble, we're still wanting to treat the person so they don't come back. So it's kind of a dual-pronged approach that we use.
I agree with that. I think I see a problem and I see suffering and I see pain and hurt. And so my mind starts racing for a solution, how to fix it, and not necessarily just win the case. And so we balance each other out in that sense. But for purposes of our discussion today, when you have a client you believe is innocent, this puts additional duties, additional considerations on us as lawyers. And so I wanted to have this discussion with you about how we approach these topics, because one of the first things is we have a duty to engage in plea bargaining. There's a Supreme Court decision, for example, that says as part of our Sixth Amendment constitutional obligation to our clients, effective assistance of counsel requires effective plea bargaining, even when you know that the person is innocent. And so how do you reconcile that with what most people imagine, that if a person is innocent, you set it for trial, you let the jury decide, and you argue your heart out?
Well, I think it's, as you said, it is our ethical duty, and the law tells us that we have to engage in plea bargaining, and any offer that comes from a district attorney, or even if the judge is making an offer, it's the law that we have to present it to our clients, and we have to counsel them on it. Some cases it's a matter of math. The offer is so good that the risk of going to trial is just not worth it. I mean, we've had cases where people have they've been offered a year, 2 years in custody of someone, and if they lose the trial, they get 30 years, 35 years, a life case. So then it's almost a math and it's a balancing thing. Are you willing to risk it?
Yeah, and what you're saying brings to mind something that happened to us just a couple of weeks ago when we had a client that I have lost sleep over, genuinely believing was innocent and was fighting for their life. At the time, they committed a homicide, and after doing a really good job examining the prosecution's witnesses, we get a probation offer. And so what do you do with a client you believe is innocent who is looking at life in prison and now has an opportunity to get probation? Do you tell them, if you're innocent, do not take it, trust me to walk you out of this mess? And then if they trust you and you fail, it's on your conscience for the rest of your life that that person is in prison for the rest of their life, you know? That's heavy. That's real.
It's very difficult at times. And how I explain to the clients is, I mean, every trial is its own little different drama. Every time we bring 12 different jurors in the courtroom, they have their own experiences and opinions on things. And what's even more telling is there's been trials that you've done and there's been trials that I've done where we know 100% the client is more likely than not to have committed what we're trying, and a jury's found them not guilty. And on the flip side, we've seen trials where we're convinced of the evidence, but the juries don't see it the same way. So we know in our souls what the risks are, and that jury trials aren't a guarantee. And so I try to convey that sense to the client that said, look, it's your life. I go home. You're the one that pays the consequences. And we do a careful weighing process. And I think for me, when they're making the decision and they're fully informed of the pros and cons, and we sit there and we go, okay, how are the jurors going to look at this bit of evidence? How are they going to look at this bit of evidence? And thoroughly vet the client, tell them what they should know, so they can make a truly educated decision. And then, based upon our combined 40 years of experience, give an opinion what we think is going to happen in jury trial. Sometimes you have to set things for trial, and you have to go to trial, and just to keep the system honest. And sometimes we don't get those offers either, and we have to go to trial.
No doubt. I mean, we've done, I think the cases you refer to are the kind of cases where our back was to the wall. We didn't have an appropriate way to resolve the case. Either the judge was not willing to extend an appropriate sentence, or perhaps we had a prosecutor who was convinced that this client deserves nothing but, the maximum sentence, and so it was back to the wall. You have to get creative, and you try a case, and sometimes in the middle of the trial, you actually find out that you were wrong about your assumptions. You were wrong in how you viewed the evidence, and you find the way to present your client's narrative and a story to the jury in a way that makes them feel that, the government failed to prove this case beyond a reasonable doubt. I have reasonable doubt about this person's guilt.
And that reminds me exactly of that case I had in San Luis Obispo, where the client came to me 3 times asking me to take the case, and each time I told her no. And because of the risk and what the evidence was, and finally she convinced me to do the trial, and I went down and did the trial, and we wound up getting a not guilty because significant evidence developed in cross-examination of the police witnesses, some of the eyewitnesses, that pointed towards exoneration. And you don't always know that until you do the trial. But the risks sometimes are so high, it's hard to explain that to people. And it's truly unique when somebody's willing to risk it all, and we just saw that recently in Salinas. But there's a lot of different options, and we didn't used to have the options that we have today. And I know, I'm pretty sure you know what I'm talking about with all the diversion, the mental health diversion, the treatment programs. I mean, a decade ago, we didn't have those things.
Right. So we came up, I think you're onto something. So Roland and I came up in a system that did not present lesser alternatives to criminal trial, to criminal jury trial, the way the system presents today. Today, a person who is, for example, someone who suffers from mental illness or drug addiction, or is a veteran, or perhaps qualifies for a number of other programs like diversion for first offenders, may get an opportunity to participate in a program that's counseling-based, treatment-based, and in exchange they get a dismissal of their case. In the system that you and I grew up in, we were able to negotiate a deal or perhaps seek a reduction, but at some point you ran out of runway to settle a case, and the only other solution was trial. And I think it helped us, obviously, develop our skills as trial lawyers, but it did not allow us to present clients with lower risk alternatives the way we do today.
I mean, we were on the ground floor of mental health courts, of veteran treatment courts. We've seen the transition of drug courts into much gentler courts where they were extremely punitive when every drug offense was a felony, basically.
Correct.
And now we realize that most drug offenses shouldn't be a felony unless people are selling or distributing large amounts.
Or have some prior record that mandates that it be a felony. Correct.
Yeah. And so we've seen the treatment take over, and I think it's done a tremendous job of reducing our prison population. I mean, the state was mandated. I mean, the prisons were busting the seams by the old approach, and the new approach is treatment, programs, and what I think you've done a good job, our entire team has done a good job, is finding the right program for the client when they come into the office so they can be treated appropriately in a humane manner and take care of everything.
And I think on a more, global level, I think this evolution in our state, the evolution of our criminal justice system, of our laws, also, I think, reduced the risk of an innocent person getting convicted at trial of something they didn't do, because now there are lesser alternatives to a process that is basically an all or nothing process. And so now a person charged with a crime they didn't commit could choose to pursue a treatment-based approach that they might benefit from nonetheless, or choose an approach that they qualify for because of their perhaps prior service in the military, and now they can get a dismissal of the case, never have to say guilty, never have to say no contest, so that only people who truly have no choice, or people who truly want to assert their right to jury trial and prove their innocence in court, go to trial.
I think you're right there. A lot of these cases that would have gone, that are marginal cases that would have gone to trial in the past, definitely are involved in treatment programs. Now, it's much easier to recommend a treatment program to a client that they're going to benefit no matter what, because even if they weren't involved in, let's say, beating their wife or something of that nature, and on the flip side of that, the cases that go to trial have been increasingly heavy. I mean, we've seen almost every case that goes to trial now, people are looking at 20, 30 years in prison.
Which jurors don't know about because they're not allowed to be told what the punishment is, and so the punishments can be decades and decades in prison. Now that leads me to a related question, Roland, and it's one of, when should a lawyer want to know everything about what the client did? Or to put it differently, when or whether a client should tell the lawyer truthfully about what happened to them. Because if we don't know the full picture, if we don't realize the depth of someone's involvement, for example, we may not advise them correctly regarding the plea bargain. So what's your take on that? I know there are competing schools of thoughts, right? So let's put it on the table. What are the two schools of thoughts?
Well, I think there's actually three schools of thought. But, okay. I mean, there's a lot of attorneys say, I don't want to know whether he's innocent or guilty because they don't want to have it taint their thought process. If you know that somebody's, no, neither of us. If you know somebody's guilty, some people, they don't put in the effort. They don't try as hard. It seems like they're trying to make a deal from day one. Whereas I believe you and I have the same opinion. We could care less. We want to know the facts. I want to know what's happening, because if I don't know every little detail, when I walk in the courtroom, the district attorney might know that detail and they're going to punk me. And I don't like getting punked. I want to be on the offensive in court. So I tell everybody details are important. I'm going to put up the strongest defense I humanly possibly can, whether somebody's innocent or guilty. I'm going to put my 100% into it. And but a lot of people don't want to know that because they don't want the pressure of doing that.
Now, I think the second part of it, so you've presented one side of it, I think the second part of it is that lawyers also have certain ethical obligations, and some clients know that. So, for example, if a client tells you a fact and you believe that, you're not allowed to suborn perjury. You cannot then, when you learn additional facts in the case, have client get up on a stand and testify in response to your questions to the very opposite of what you know is the truth. And so I think a lot of people are concerned that, hey, if I tell my lawyer the truth of what happened, I'm not going to be able to later evolve the story into something that helps my case better, right?
I think that's a fear that some people have, but I want to know the facts and I will figure out how to make it work. It doesn't matter. We're not here to come up with a story. We're here to make the government prove their case and put up the best defense for our clients that we can find, and we do that in spades.
And I think when you know that your client has done something wrong, that also enables an additional level of understanding of perhaps how the person came to be involved, what opportunities we can find to fix the behavior that led them to that situation in the first place. And oftentimes we end up with far better results, both legally and personally for that person, as opposed to finding some way to, fabricate a story or a defense that only compounds person's transgression and not one that I think opens a new chapter in their life. I just don't think that's a right thing to do. It's also illegal, but it's just not the right thing to do morally.
It's not the right thing to do, and it's not good defense. I also think when we know everything, even when they've told us things that they might have done wrong, it gives us a certain freedom in the courtroom, freedom to argue, freedom to go as hard as we can and fight and come with the best result. But quite often, people tell us they did something, but they're charged with something much, much, much worse.
The majority of the times that I'm in
Yeah, actually, it's the majority of the time. And so... And the government's stuck on a different charge. And what we're looking at is trying to get the government to realize, hey, this guy did something, but it's not what you said.
And I think that's why I agree with you, Roland. I think that's why honesty with your attorney is very important, because even though you might be admitting to some wrongdoing in a case, that might actually be a great defense. You might be admitting to something that the government can no longer charge you with. You might be admitting to your lawyer something that the government does not want to charge you with because it would present the jury with an option of acquitting you on a more serious charge and convicting you on a far lesser charge. I've had a murder case, for example, where my client was clearly an accessory after the fact by helping the actual participants in a murder get away with it. The government could have easily charged him as an accessory and obtained a conviction and sent him to prison. But the government didn't want to do that. They got greedy. They wanted a murder conviction. And as a result, they lost entire case in trial. And that's what the jury found too. And so I think honesty is good for the client. It's also good for the case. There are some scenarios, obviously, where you might be stuck with client telling you, yes, I did shoot this person dead because I hated him, and now you cannot put the client on the stand to testify that I was in Timbuktu when it happened. I mean, that's true. And then you just deal with it within the framework that the legal system allows, and there are other ways to argue and manage without suborning, false testimony. But you've mentioned that there are three competing thoughts. So one competing thought is that, or one school of thought is that the client should always tell the attorney the truth so that the attorney can be best prepared to handle the case. The other school of thought is I don't want to know anything because it's going to taint me somehow and make me less objective. And I guess what is the third one?
Well, the third one is really attorneys that want to shape the narrative before they talk to their client. They look at the crime and they look at the police reports and they try and come up with the defense, and then they shape what their clients are telling them. But in those cases, I think they're only deluding themselves.
Now, what, Roland, do you think are the factors that any person, and especially an innocent person, should consider when they are presented with a plea bargain?
Well, anytime that you're presented with a plea bargain, you need to start with internally, the person needs it in themselves, because whether we think they're guilty or we think they're innocent, they're the only ones that truly know whether they're innocent or guilty. So I said to people, you need to look inside yourself. You need to have that moral fiber to see where you're at. And then we look at the evidence and we do a weighing process. So you have to look within yourself. You know what you actually did. And then you have to look at what I'm being offered. Is it a good offer? Is it a good resolution that we have worked out? Because usually what the district attorney offers initially is not what we work out.
Sometimes it is.
Sometimes it is, but not always, yes. And so we have to say, and we're going to tell them, look, historically, in these types of cases, this is where they resolve. You're way better than that because of these factors. And we have to present the factors that led us to be able to get a better outcome for these clients. It's because we had them either in early counseling, marriage counseling, we had them in therapy, drug treatment, all the things that we front load a case in to help us in those negotiations. And so we talked to the people about all the work they did. And then realistically, it's a weighing of the risk. If you're offered 1 year and you go to trial or probation and you go to trial and you lose and you're going to get 17 years, well, 1 versus 17, it's not a really good risk. Now, if somebody's looking at 5 years and the maximum they could get if they go to trial is 6 years, let's go to trial. We call that a free trial because there's no risk. I mean, and quite often, usually in those cases, we beat the offer because the district attorneys, they're like throwing up their hands in those cases. They don't know what to do for whatever reason.
Let me introduce a related topic. So people outside of our industry probably don't know that, and it is illegal, but it happens all the time. Have you ever heard of trial tax?
Okay, yeah. Trial tax is when, prior to trial, we present facts to the judge. We talk to the judge about the case, and the judge gives indicated sense. Well, assuming he pleads to 2 counts of armed robbery, he's going to get 6 years in state prison. And then we go to trial, and they lose, and he gives them 12 years in state prison. And we're like,
where did that come from, Your Honor?
And he says, well, he testified on the stand, and I didn't believe his testimony, so that gives me a reason to give him more time. Realistically, the judge is sending a message to everybody, don't bring these kind of cases to my courtroom.
And I think, unfortunately, what happens in a number of these cases is that our system is not designed to handle everyone charged with the crime going to trial. There's not enough human resources, there's not enough courtrooms, there's not enough courthouses. 90 to 95% of all criminal cases, statistically, will settle or have to settle in jurisdictions where, for example, the public defender's offices and public defender offices that are well funded, that are well resourced, can play an incredible role. And you and I have both come from public defender backgrounds, so we know the importance that a good public defender, not a bad public defender, but a good public defender can play in a courtroom and in our criminal justice system. But if you had a public defender who, for example, set majority of their cases for trial, the system would choke. They just wouldn't be able to process all of these cases.
That's correct.
And as a result, and what has happened to my clients in the past when I've tried to do that, the courts can get very punitive when you practice in that way and your clients lose, specifically to send a message, just like you said, specifically to deter people by saying, look, if you mess with the system, if you don't take these reasonable plea bargains, if you go to trial and lose, you're going to have a catastrophic sentence, so that everybody remembers not to do that again. It's a travesty and it's a tragedy and a miscarriage of justice. But it is a fact. It happens all the time in virtually every jurisdiction in our state.
I do think there's been a change over the last few years in the trial tax. When we first started, every judge was an ex-district attorney. And what they considered a reasonable offer quite often wasn't reasonable.
No, I still remember one of my favorite judges who used to give me the greatest smile whenever we would discuss a case, and he would just say, it's time, Mr. Pernik. And what that meant was, it's time for your client to go to prison, Mr. Pernik. Now, when you did a trial with this particular judicial officer, you had an incredible opportunity to prove your client's innocence. He was a great trial judge, gave you every chance under the sun to prove your client's case, and so you could get really incredible results in his courtroom because he was a great judge when it came to ruling, evidence, letting you be the attorney that you needed to be for your client, but God help you if you lose.
And we know which judges those are still to this day. And I take that into consideration when I talk to my clients. I say, look, this judge is going to give us a great trial, but if we lose, you're going to get a big sentence. And other judges, I said, well, the trial might not be so great, but he's very light on sentencing at the end.
Yeah.
Or she. Actually, we probably have more female judges now than male judges.
Which is a really good thing, I think, in balancing out some of the unfairness in our system. The more people we bring into the system from diverse backgrounds, from different ethnicities, obviously increasing diversity promotes equality, I think, and I think it softens the blow that sometimes people get when they lose. Sometimes, not always.
It does. Sometimes it does.
Yes. We also came up in a different jurisdiction. We learned how to be lawyers in a very conservative Central Valley County. So a lot of the experiences we have here on the coast or in Santa Clara County are vastly different from what we had, experienced early on. But nonetheless, lessons were learned.
Yes, they were. So William, we've been talking a lot today. Now I know we're talking about presenting offers. Now, how do you present an offer to a client? And does it really make a difference to you when you're presenting the offer, whether you personally believe the client's innocent or guilty, or does that change your presentation at all?
I think if I'm honest with myself and our audience, I think it does. I think it does make a difference in how I feel. But that is because I practice law in a very personal manner. I try to live the cases through the eyes of my clients. I try to put myself through what they have gone through. And I try to build a rapport with my client early on in the case so that they know I'm not just their lawyer, I'm also their counselor. I am here for them. I care about what happens to them. And so that opens up for us an additional level of understanding and I think frankness that allows for conversations like, look, between you and I, we both know what actually happened. We both know that some mistakes were made, that you perhaps didn't use the best judgment. I'm not here to judge you, but here's the circumstance that we have, and here's your exposure, and we don't want to compound one mistake with another. And I think that's very different from us having a conversation where we say, look, you know that you're innocent. You know that I care to see you free. What really keeps me up at night is my fear that despite the best possible job that I do for you, you could nonetheless be convicted of this. And so I think the way I speak to a client differs based on that understanding because, again, I practice in a uniquely personal way. That being said, I go through the same steps because I think these are important steps that every legal professional should take. And that starts with, number one, reviewing the evidence in the case. Number two, investigating any and all possible defenses. Legal defenses, meaning maybe it's a self-defense, maybe this is an accident, maybe this is necessity, maybe this is mistake of fact, any potential mistake, maybe it's mistaken identity, whatever the legal defense could be. And then we investigate factual defenses to the crime that require us using our private investigator to talk to witnesses too.
Let me hold on. But these are all steps that you're taking as the case is moving along. All this has already been done.
So this has been done.
And this is what you're presenting to the client, the work that we've put in, what we've done, how we've investigated it.
I summarize it. I basically say, this is where we are in the case. This is what you're charged with. This is what the maximum sentence is that the offense carries. We know that, or we believe that if you were convicted of this offense, you would likely receive a sentence in a range of this. And that could be in years, it could be in months, it could be in days. It just depends on the crime. Were we talking about a misdemeanor? Are we talking about a felony? Are we talking about a felony with some enhancements like use of a firearm, being in a gang? Are we talking about a homicide, God forbid a sex charge, which opens up its own can of worms, and that's your primary can at the moment. But we discuss the offer always in the context of the evidence in the case. Sometimes the offer comes in early, before we've had the chance to fully develop our legal theory. And so we have to be, at our core, honest with the client. This is an offer that we have received. We are early in the game for this case. These are the things we can continue to look at. This is what we hope to discover or uncover. If this pans out, this is what's going to happen to you, and this is the best case scenario, middle scenario, worst case scenario. But we always discuss the offer in the context of the evidence in the case and our goals and objectives. We also set objectives early on in the case. I don't know how you do it. I assume it's very similar to how I do it. But I always, at a consultation, discuss with the client, what is your objective? What is it that you hope to accomplish? And so if we have an offer that accomplishes that objective, I think that's very important. important, then we can have a conversation about, look, when you and I first started to work together, your objectives were, for example, to not do jail time, to not have a conviction that's going to affect your professional license, to be able to come back home to your family. We now have an offer that meets all of these requirements, but it does require you to plead to something and do some community service, for example. Can you live with that? I know that you have some strong defenses. Do we want to present the case to the jury? Are you comfortable with the additional risk? Because if you're convicted, you're going to get a far worse sentence than that. So I think that's my process. Always summarize where we are in a case, always summarize the evidence in the case, make sure the client understands what the evidence is, then explain the risks, explain the benefits. Now, in my experience, Roland, I found that there are three scenarios when it comes to plea bargaining. Sometimes you have a really bad case for your client and a really great offer. Those are easy decisions on settlement. If you have a really bad case and a really great offer,
or a really great negotiated resolution.
Or a really great negotiated resolution, you jump at it. Okay? Now, sometimes you have a really good case, and usually those cases, unless your prosecutor doesn't know how to read her file or his file, usually those result in pretty sweet offers too, because the other side doesn't want to lose a case. So I think in those circumstances where you have a good case for one side or another, there is typically a resolution that's easy to achieve. The hard cases to settle are cases where you have either a really bad case and a really bad offer, or a really good case and a really good offer, when you don't have those extremes.
Well, I think the really good cases for us are the ones that usually get the good offers because the district attorneys do read those and they see that. Sometimes I think for myself, the ones that are the hardest, and I believe you probably think it's the hardest, the ones that have the worst facts and the worst offers.
Yes, definitely.
But usually by working hard, I mean, those aren't the cases you don't just give up on those cases. You keep fighting, right?
And again, it's also very important for us to have a client that is honest with us, I think at least for my practice and for yours, because sometimes we have a client who, for whatever reason, maybe because of their prior experiences with bad lawyers, maybe because of what their cellmates are telling them, maybe because of their preconceived notions, but they think that they need to insist on their innocence falsely in order to get their lawyer to work hard for them. I understand why it happens, but it can be really counterproductive. You and I had a big case a number of years ago where we genuinely believed the client was innocent. And had we known some of the additional facts about the case the client didn't share with us, we probably would have put the case in a different timeline. We would have expedited a jury trial. We would have asserted our right to speedy trial in the case before the government could develop some of the additional evidence in the case. Because of what client told us, we were not as concerned about some of this evidence being developed because we thought it wasn't possible that any such thing would exist, since we believed this particular client. As a result, case got worse. This happens, and I think that's another reason why it's important for us to know what's going on so we could anticipate possible issues in the case. And that's why I believe honesty is preferred.
That's an interesting point, because some defense lawyers say that aging a case never hurts. The best thing for a criminal defense is to age the case. But quite the opposite sometimes. We found it when you have a government that's well motivated and has 20 investigators full-time sitting there fully funded, and they go through somebody's phone. Now that I'm thinking about it, it's much more so because of more technology now. When they have the time and the resources, they're getting the Google records from the phones, they're tracking the cell phone towers, they're finding videos that pop up from everywhere. 20 years ago, we didn't have the cell phone tracking, we didn't have Google tracking, we didn't have this stuff. So the time of aging the case was more so with hurting memories and stuff like that of people. But now, aging a case, sometimes it gives the government time to really develop that type of evidence.
I agree. I think that's true. I think we need to take into consideration the government's ability to use all the technology and science that has become available now in order to prove their case, and that factors into the decision also when you're discussing a plea with the client as to, if you wait too long, what else can they do to prove your guilt? Do you want to take that chance? Do you want to wait for fingerprints? Do you want to wait for DNA? Do you want to wait for hair analysis? Do you want to wait for additional forensics? All of these things take time. You and I know approximately how long the turnaround is because we contract with similar experts, and so even though on the civilian side of it, we might sometimes be able to expedite it by paying, but I think we get a general idea of what a turnaround is.
And 100%, that's important for a client to be truly honest with us on that stuff, because then we can make an educated decision on what
Should you wait? Should you not?
Should you wait? Should you not?
Exactly.
Yes. And so, wrapping this up, I mean, I think that would be one of the main decisions why somebody that we potentially think is innocent would take a deal or an early deal, because of the ability for the government maybe to develop more incriminating evidence. That would be a tremendous reason, right?
I agree. And I think also we have to remember and we have to remind our clients that unfortunately, in the system that we have, it's often not what you actually did or didn't do, but it's more of how does it appear. And a skilled, motivated, dedicated, well-resourced prosecutor can oftentimes build a case, and a strong case, and a persuasive case that a person is guilty even if that person is innocent, because they can use circumstantial evidence, they can present all kinds of inferences to the jury, they can develop snitches who lie their hearts out or whatever they have instead of a heart in some of these cases where you know somebody's falsely accusing your client and making up things, and that's just morally and legally wrong, but it happens. If you get a motivated in-house informant, you know, sometimes we have an innocent client who we know is innocent, case is going great, and they carelessly shared police report with some, you know, friendly legal assistant in jail, and before you know it, you now have a snitch or two snitches, and the government feeds them just the right information for them to be able to corroborate their BS, and now you have a high risk of conviction. You got to advise your innocent client, like, look, we told you to be careful, you weren't careful, this is what this person is saying, it matches the government's theory of the case, your risk of conviction gone up. Consider your next steps carefully.
So if we're going to wrap this up, let's give our viewers maybe the top 5 reasons why an innocent person would plead guilty.
I think number 1, a person may be afraid that even though they are innocent, their story may not be believed, or there might be an appearance that they're guilty.
And number 2, when somebody has a resolution on the table that is so good that it tremendously outweighs the risks of going forward with the case. I mean, if they're getting a treatment program as opposed to going to trial, they really need to consider a treatment program and walking out the courthouse a free man or woman.
Third one would very likely be the impact that it might have on their loved ones. Oftentimes in cases where somebody's falsely accused of domestic violence, or perhaps even sexual assault, or some other conduct that involves a friend or a family member, oftentimes the very process of going through a jury trial and presenting a defense involves getting your loved one on the stand and being exposed to questioning and cross-examination. And it could be a child, it could be your pregnant spouse, and it's difficult for people, so oftentimes people consider extraneous circumstances, even though we tell folks to decide what's in their best legal interest, but human nature is such that life is complicated and other factors may be considered.
That's true. A fourth reason why somebody might plead guilty is that there's a tremendous amount of evidence that really points towards guilt. And when they look at it, the risk of going to trial and the likelihood of getting convicted is tremendous, even though they're asserting their innocence.
I think sometimes it happens, Roland, when people do not seek qualified legal assistance early on in the case. There could be a colossal failure to preserve exculpatory evidence that is material and points to the innocence of a person. Let's say someone had a lawyer who didn't bother talking to them for the first 5 months of their case, and this is a consent defense, and there are text messages that are sent using either a burner phone or one of these temporary devices that don't keep data for a long period of time and will lose it within 30 or 60 days, or perhaps uses Snapchat or another application that does not store information for a long period of time. If there is a failure to preserve evidence, they might fear that even though I know I'm innocent, evidence of my innocence wasn't presented or wasn't preserved, rather, and now it cannot be presented. I think that's a problem. So lack of adequate preservation of evidence, both by law enforcement at the outset and later on by a person's attorney, hopefully before they come to us, that could be a reason why a person pleads.
Fifth reason that I wanted to cover, people wind up in court, they get arrested, they're taken to arraignment, and they get appointed a public defender who hasn't even read the case. Public defender goes to him and says, well, Mr. Smith, if you plead guilty to this, guess what? The court's going to release you today. That's a tremendous problem. It creates a lot of convictions And they call it early resolution court, but I know you have another term for it.
Yes, I do.
Yes.
I call it dump truck court.
Dump truck court, yes. And that's, to me, that's the fifth reason people participate in dump truck court.
And that's not something unique to any one area. I think our system has wisened up over the years that courts are congested, dockets are long and crowded. And so in multiple jurisdictions, from Central Valley to the coast, north to south, they've come up with these courtrooms that are filled essentially with lawyers who are assigned there for the moment, people who don't have a vested interest in the case, lawyers who will not see the case from beginning to an end. And so there is, a public defender on duty, a DA on duty, and they're trying to engage in this plea bargaining before anyone's actually considered the merits of the case for one side or the other. And I just don't think that's...
Or the impacts on everybody's lives.
Right? And people are getting an offer to get out of custody, and if they don't take that offer, they stay in custody. I had a judge who was a very experienced judge of many, many decades, probably 4, maybe longer, when I was a young public defender in dump truck court. And I remember vividly that the offer to my client, a female who was charged with domestic violence, was credit time served if she pled. She was in court in jail. Her children were at home. Had she taken the deal, she would be released the same evening. But she was innocent, so she did not want to take the deal, and she wanted to set the case for trial. So I'm setting the case for trial on her behalf. The judge refuses to release her. So of course I object by saying, well, Your Honor, you said if she pled, you were going to let her out, and now that she's refusing to plead, you're punishing her by keeping her in. And of course the judge got really upset with me for saying that, but that was true. That's the reality.
Absolutely true.
And it plays out every single day.
We want to thank you for watching this video today. If you like this video, any of our other videos, please hit the like and subscribe button. We appreciate it a lot. Thank you.